I wanted to discuss the issue of whether legislative intent statements should be codified or not. On occasion, California legislators include statements of legislative intent, or they make some findings and declarations in their bills. Now, when you review these bills, you'll see that in most instances, these statements are uncodified. Usually, you find them at the beginning of a bill before the statutory language. In more limited cases, these statements are codified along with the other substantive statutory provisions that are contained in the bill. And this to me raises the question whether these legislative statements, again, of intent or findings and declarations, whether they should be codified or not. Of course, what's the definition or difference between codification and uncodified statutes? Essentially, codified laws are all the statutes that are contained in the codes in the state of California. There are 29 of these codes. They begin with the Business and Professions Code, and they end with the Welfare and Institutions Code, with, of course, 27 other codes in between. And codified laws are those that are of general applicability and are deemed to be permanent in nature. Now, on the other hand, those that are not permanent in nature are usually of a specific rather than a general nature, are those that are uncodified. Now, despite that, these laws are enacted each year by the California Legislature. Uncodified just means they're not placed in one of those 29 codes. The biggest example, at least in terms of length of an uncodified law, of course, is the annual state budget bill. Now, whether codified or uncodified, both are written laws that were, of course, passed by the legislature and signed into law by the governor. Now, codified laws, again, in theory, can be easily found amongst those 29 codes. Uncodified laws sometimes are a little bit more difficult to locate. For example, you may have to review a volume that's called the California Statutes and Amendments to the Code in order to find uncodified laws from a particular legislative session. Sometimes if you review the annotated codes of Wests or Deerings, you can find references to these particular uncodified statutes. Now, returning to the initial question I pose, different states in this country have different views on whether to codify legislative findings or other statements of intent. For example, in Utah's legislative drafting manual, I found this provision. It says, quote, "If, however, a legislative statement is included in a bill, it should be codified. An exception to this general rule is a legislative statement related to a specific time-limited action to be taken by the legislature or executive branch agencies that is not generally binding on the public." And they give a few examples: specific state appropriations, coordination clauses, revisor instructions, a study, or even direction to a state agency to take some specified action. Now, California, on the other hand, doesn't have a specific rule related to whether these legislative statements should be codified or uncodified. Again, while some state legislators are reluctant to even include these statements in bills, I think they're found on a more regular basis with California bills. One state drafting manual says quote unquote, a well-drafted bill ideally expresses legislative intent in the body of the bill itself, which makes a legislative statement unnecessary. Not all states agree, certainly not California's. In my years of reviewing California legislation, I find the most common usage of legislative intent statements or findings and declarations are generally in uncodified provisions. As I mentioned at the outset, usually found in, say, Section 1 of the bill, before Section 2 and what might follow will include the more substantive codified statutory language in that particular bill. Now, these statements of course are intended to provide guidance in interpreting the bill's provisions, and that guidance might be, of assistance to, say, regulatory agencies that have to interpret or enforce or make specific with regulations, or of course, ultimately to the judicial branch of state government in their interpretation of what these statutes may mean. So again, I come back to that question, does it matter whether these statements are codified or uncodified? I'm not aware of any California appellate court decision that draws a distinction. Whether codified or uncodified, they're both statutes that have been enacted by the legislature and governor. So in theory, therefore, they would be of equal value. Nonetheless, I've seen some commentators who viewed codified statements of a legislature as carrying more weight, especially because they can be readily found as part of the statutory language.